For the record, please.
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
Randall Upshaw, on behalf of Mr. Smith, P number 135, second court, state your name, sir.
D.R. Smith.
There's the date, time set for preliminary examination. Are you ready to proceed?
Your Honor, the people are unable to proceed. Necessary witnesses now have been made aware of the date, but they are not present.
Your Honor, we're asking the court to dismiss. Court will dismiss this matter without prejudice. Thank you.
Thank you, Judge.
Yeah.
Good morning, Ms. Silver. What can I do for you?
Good morning, Judge. I was asked to sign on with Ms. Bickerstaff regarding scheduling of our exam for next Thursday on a Joni Lotto.
Yeah.
She's on Zoom.
Yeah.
Okay.
Tell us we have it here, because I got to get it for you.
Don't get their numbers on the back of it. I'm gonna.
Send a lot of those.
It's been processed. It'll be a short. Let's go.
The case number 405-72-5101 for the state of Michigan versus Joni Alato. Defendant is charged in counts 1, 2, and 3, homicide, felony murder. Counts 4 and 5, assault and intent. Count 6 through 10, robbery, count 11, weapons, firearms, possession by count. 12 through 22, weapons, felony, firearm. Defendant has a habitual offender or defense notice mandatory 25 years sentence.
Appearances for the record, please.
Good morning, Your Honor. Anna Bickerstaff on behalf of the people, P82215.
And good morning, Gabi Silver appearing on behalf of Joni Alato. Judge, I had asked immediately following the setting of this exam date, I realized that I had a waiver trial scheduled for that morning. I had asked if we could alter the date by just, or the time rather, by maybe moving it to later in the morning or that afternoon. We did hear back from your clerk this week indicating that you already had an afternoon exam. I'm asking if we can just move it by an hour and at least get started. Maybe move it to 11. I doubt we would finish, but at least we could get some witness done.
How many witnesses do we have on this, Ms. Bickerstaff?
And my apologies. I just,
It's either going to be 1 civilian or 4 witnesses, depending on how the proofs come out.
I do have you guys scheduled for 10 o'clock. I have an 11:30 and I have a 1:30.
Yeah.
I could do July 2nd.
It works for the people.
Oh, you know what?
I'm in.
Take that back. I'm not here July 2nd. Okay, let's try to make June 27th work then. 11 o'clock.
That works for the people.
Ms. Silver? I think Ms. Silver froze on.
Oh.
Okay, we'll say tentatively June 27th at 11 o'clock instead of 10 o'clock.
Thank you, Judge.
We continue. Mr. Johnson, good morning.
Good morning, Your Honor. I'm here on Corintha Bush. APA Vela was supposed to be here. I think he was in the waiting room, but he was talking about leaving. It's just for PCC, Judge, homicide.
I'm gonna need him here to discuss what date.
Yeah, I know, Judge. I mean, I had to be somewhere at 9 too, so I don't know why he left. I told him that you were coming right on the bench. So if you want me to, obviously he's left, so you want me to zoom back in. He said something about 10:15.
Who was it? Who was the APA?
Vela, let me see. He
Mr.
just
Vela?
yes.
Okay. All right, you can come back.
Okay, will do. Thank you.
Thank you.
Morning, Judge. I have Miss Silver next to me. This is Arnie Chambers.
Oh, okay.
She was asking for confirmation. Forgive me, she can't hear because I have these earphones in and I don't know how to cut them off without.
All right. June 27th at 11 o'clock.
At 11 o'clock, June 27th. She's acknowledging, Judge. She said okay. Thank you. And she apologized, but I don't think there's a need. All right, I'll be quiet and wait for my case, Judge.
All right, thank you, Mr. Chambers. Ms. Walrat.
Good morning, Your Honor.
Good morning, what can I do for you?
I have a PCC for Javante Briggs. I wanted to see if he's in the waiting room.
He's in the hallway.
Oh, he's in the hallway. Okay. If he could, well, I'm on Zoom, which isn't ideal, but if he could come in and if the bailiffs could get his phone number so that I can get his working contact information.
Why don't you give him yours?
Oh, that would work better, Your Honor. Correct. You're right. Mr. Briggs, I haven't been able to contact you. Can I give you my phone number and then we can have a call and then we can come back to the courtroom after we've spoken briefly?
Yes.
What?
What's your
Okay.
numbers?
It's 313-569-7131.
Second. Okay. Ready to call Briggs.
Calling case number 2405-776-501, people of the state of Michigan versus Javante Briggs. Defendant is charged in count 1, weapons, firearm, possession by a prohibited person. Count 2, motor vehicle, unlawful driving away. Count 3, assault with a dangerous weapon. Count 4, weapons, stealthy firearm. Count 5, domestic violence. Defendant has a felony commission with the motor vehicle adult advisory.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drake, people, P number 60249.
Good morning, Your Honor. Veronica Walred, P85665 on behalf of Mr. Javante Briggs, who's present physically in the courtroom. Mr. Briggs, could you please state your name for the record?
Javante Briggs.
All right, what's your pleasure, Ms. Walrat?
Your Honor, we would like to set this case for preliminary exam. I do have paper discovery and I'll be able to share that with Mr. Briggs. I would ask if the prosecution could send me the digital discovery if that has not already been sent.
I will send it to you right now.
Thank you.
How's June 28th at 9:15?
1 second for my calendar to load, Your Honor. The 28th at 9:15, likely not possible. But if there's a time later in the morning, that would work.
10:15?
10:15 would be good.
All right, June 28th at 10:15, we continue if there's no objection.
No objection.
All right, continue.
Mr. Briggs, give me a call as soon as you get out in the hallway or a text, okay?
Yes.
Okay, thank you.
Mr. Chambers.
Yes, Judge.
Good morning, sir. What can I do for you?
Good morning. I'm on Barry Love. I believe there's a co-defendant and certainly a special prosecutor.
Who's the co-defendant on that?
Anthony.
It's Mr. Carter, Judge, and I have both, and Mr. Kenneth is Mr. Carter.
Okay, great.
Juvenile have both of them.
They have it logged on.
They have both of them.
Right here.
Yeah, it's up under their name.
Okay, I see. Okay, we're ready.
Calling case number 2405-7709. People, State of Michigan versus defendant number 1, Anthony Carter, and defendant number 3, Barry Love. Both defendants are charged in count 1, homicide, felony murder. Both defendants are charged in count 2, robbery armed. Both defendants are charged in count 3 and 4, weapons, felony fire.
Appearances for the record, please.
Good morning, Your Honor. My name is James Kehoe. My P number is 82812 on behalf of the people.
And may it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki, P 64800 on behalf of Mr. Carter.
And good morning, may it please the court, Arnie Chambers, P 63956 on behalf of Mr. Love.
All right, what's your pleasure, gentlemen?
Your
Judge,
Honor, I'm sorry, go ahead. Go ahead, Mr. Chambers.
No, I need discovery. I don't have anything, Judge, at this point.
Judge, I've been out all week, so that's my fault. I got this case when I've been out, but that's forthcoming, Judge.
And Your Honor, I believe I also need discovery. And then in speaking with Mr. Carter's family, they were requesting if we could request an adjournment. They wanted to hire counsel and they wanted a little bit more time. So it does sound like we need to get a little more time to make sure everybody has discovery anyway. So I'd ask to set an exam date or adjourn this for a week or so, or set an exam date out a little bit so that we can ensure that we have everything.
Mr. Kehoe, when are you going to get them discovery?
I can start working it this week, and it came in when I've been gone, Judge, so I apologize.
All right, I can set this matter for preliminary examination on July 9th.
Judge, I will be out of town the week of the 8th.
July 15th at 11:30.
It works for me.
I can make that happen, Judge.
July 15th at 11:30. That should be good, Judge.
All right, July 15th at 11:30 at the both defendants. And bond will be continued.
Judge,
Thank you, Your
with
Honor.
regards to bond, you know, obviously I'm at a disadvantage. I don't have any discovery at all. I barely know what this case is about. I have a very minimum idea. With that said, I mean, my client's clearly indigent, I believe by definition, due to his age. And he has no ability to produce any money for a bond. I understand the charges. I'd ask for home confinement, Judge, or request a DSU at minimum.
Bond will be continued. Defendant will be remanded for the safety of the community. I will, however, refer to pretrial services for bond recommendation if you like.
Yeah, that's what I would ask, Judge. And just to be clear, the current bond is what? Because I have one thing on my paperwork, but I believe you said another.
Court is setting that remand.
Okay.
Your
That'll
Honor,
be at
second.
Yes, sir.
Your Honor, ask for a DSC report for Mr. Anthony Carter, and then ask if, as when we're completed, that if I could have a breakout room with him, please.
All right, court will refer his matter to pretrial services for bond recommendation as well. And hang on a second.
Mr. Love, I will be back there to see you in short time. Give it a few days.
Hey, Mr. Kenneth.
Yes, Your Honor. Thank you.
All right, Ms. Constantino.
Good morning, Your Honor.
Good morning. What can I do for you?
I am here on Kelvin Craig.
All right, okay.
Case number 2405 774301, people of the state of Michigan versus Calvin Craig. Defendant is charged in count 1, homicide, murder, first degree premeditated. Count 2, weapons, firearm, possession by felon. Count 3, weapons carried concealed. Counts 4 and 5, weapons, felony, firearm. Defendant has a habitual offender for defense notice, mandatory 25-year sentence.
Appearances for the record, please.
Good morning, Your Honor. Sarah Bonoma on behalf of the people, P84189.
Good morning, Your Honor. Christina Costantino, P79668, appearing on behalf of Mr. Craig. And Judge, I don't know that he's on Zoom.
Are you waiving his presence for purposes of this hearing?
Judge, if the court cannot bring him on today, then I would, but I would rather he be here.
I don't know when they're going to bring him.
Understood, Judge. If that's the case, then yes, I'd waive his presence, especially given the circumstances of what we need to discuss today.
Court will waive the defendant's presence. What's your pleasure?
Your Honor, at this time, I believe we have an issue concerning a protective order. I was presented with a protective order and informed that it is essentially a prerequisite to obtaining discovery. Said protective order, in my opinion, is extremely broad. It prevents me from providing my client with any evidence obtained by myself, by my investigators, or any agents of mine, and that it also requires that I get the court's permission every time that I provide my client with any form of personal identifying information. Such protective order, especially one that is so broad.
I need personal identifying information.
Well, Your Honor, given that I don't have said information and I know very little about the facts of this case, I can't exactly state that. However, I could fathom many circumstances where phone numbers could be of issue, where addresses could be of issue. It's my understanding that there was some clothing that was taken from a particular address. I need to discuss said address and circumstances with my client. And quite frankly, I could hypothesize all kinds of circumstances where I may need to discuss said information with my client. But at the end of the day, I don't believe that people have a legal basis to require redaction of such information. Under the case law established by the Michigan Court of Appeals and People v. Jack and People v. Artermenian, the people must show good cause and specific good cause to the case in order to redact victims' or witnesses' contact information. The contact information at issue is, given the nature of the case, I'm assuming witness information. And although in those two cases, Your Honor, the prosecution made similar arguments as to, I'm sure, what will be made here, that witnesses have a right to privacy and that there are concerns for witnesses who don't want individuals having their personal information. However, the Court of Appeals has stated that alone is not enough. And especially in assaultive cases or prosecutions where the nature of the crime is assaultive, that is not enough. And there must be some specific good cause that the court finds, especially for a protective order of this nature that is so broad. It prevents me from providing my client with information that I obtain and also that my investigators obtain in the course of their investigation.
Ms. Bonomo?
Your Honor, I'm just asking pursuant to MCR 6.201E that there's a good showing of good cause that the court may enter an appropriate protective order. When I'm talking to defense counsel, I'm saying you can have all the discovery that's unredacted. You can have access to that. Any third parties that you're working with, absolutely. Your client in jail cannot have the phone numbers, addresses, and dates of birth of these witnesses. That's the only thing that is being asked not to be shared with the defendant. So the good cause is we have an M1 case here. We have 2 witnesses. It's from my understanding from the officer in charge, he's already been in contact with these witnesses. They were all living together at an address. He knows that address where they recovered the shirt from. And it's my understanding that he's having third parties go over there to remove the hot water tank and turn off the electricity. So there's already been contact. So I'm simply asking for him not to be given just personal information, phone numbers, birthdays, home addresses. That's it. Defense counsel can have it, but I don't understand why her client would need the address and phone numbers of witnesses and date of births.
I might respond, Your Honor.
Please.
Thank you, Your Honor. For starters, the case law that's established deals directly with this issue on point, and it states that such information, specifically contact information of witnesses, cannot be redacted unless there is something specific to the case that shows there is a direct need.
It's only being redacted as it relates to your client. You can have it, your investigators can have it, but you can't give it to your client. And I can't imagine why your client needs it.
But Judge, it impedes my ability to continue to represent my client in the best way possible because I very well may need to discuss said addresses with my client, said phone numbers with my client. I'm sure there's phone records that are in this case. I will then not be able to the people indicated these parties know each other. I need to discuss contacts with this party, and I can't do so unless I'm able to provide them with such phone numbers so that they know what this individual's phone number was when they had contact with said individual. I mean, the list goes on, but at the end of the day, Judge, the case law says that absent some specific good cause showing that's unique to this case that isn't the same as other assaultive cases, this isn't permitted. And this case law—
I am going to permit it, and the court does find good cause. And the good cause is that the pending charge here is first-degree murder premeditated, first and foremost. Secondly, I'm told that your client has already made efforts to contact the witnesses in this matter. So based on that, the court has some legitimate concern for these witnesses' safety. As such, the court is going to enter that protective order. You are not to share those personal identifying information to your client. Understood?
Understood, Judge. My only other concern is that the way the protective order that I was provided with reads, it does not read that it is just that personal identifying information. There is specifically a clause that says any digital evidence relating to the investigation obtained by me, investigators, etc., cannot be provided to my client. So I would ask that protective order to be amended to state any digital evidence containing personal identifiable information.
And that's fine, Your Honor. I'm not sure which portion that you're reading, but I can adjust that.
Okay, you guys together on that. If you can't resolve it, bring it to my attention.
Okay.
Thank you.
Thank you, Judge. And I think we'll need a new date as well.
Go anywhere, Mr. Dox.
Yes, sir.
Okay, now, as it relates to the preliminary examination, are you demanding an exam, Ms. Constantina?
Yes, Judge, we will be. I would ask for some time, given that I was just provided with an investigator's report, and I don't believe that's all the discovery just yesterday. And Judge, just so you know, I was just provided with a protective order yesterday afternoon. So this issue did just come about, even though I did request discovery last week at the time of appointment.
July 9th at 10 o'clock.
Judge, I apologize that I have 2 other exams that morning. Is it
I'm in
at all
trial.
possible to do a different date?
When does your trial start, Ms. Malone?
Your Honor, it starts on July 8th. It's for sure going. This is the second time it's been adjourned. I anticipate that it'll take the full week. It's just a fatal vehicle, but defense counsel is bringing in an expert. I have a lot of officers, so.
July 15th is my last offer at 1:30.
That works for the people.
I'm sorry, July 16th.
That works for the people.
And Judge, would that at 1:30?
I can do 1:30.
Oh, okay. Thank you, Judge. That works for the defense. Thank you very much, Judge. Have a great weekend.
Thank you, you too. Yes.
Case number 2405751601, people of the state of Michigan versus Gregory Scott. Defendant is charged at count 1, assault with the intent to do great bodily harm, less than murder or by strangulation. Count 2, domestic violence. Defendant has a habitual offender, second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drake for the people, key number 60249.
And good morning, Your Honor, and your staff, Attorney Quentin Dox, number 79657, on behalf of my client, Mr. Gregory Scott. Mr. Scott, please take the full name for the record.
Gregory Allen Scott.
Today is the date and time set for preliminary examination. Are you ready to proceed?
Your Honor, I'm not able to proceed at this time. The complaining witness was notified of today's date, time, and location for this exam. She is not present. I cannot proceed without her testimony.
I support this without question.
So order, court will dismiss this matter without questions. And thank you for being on time, Mr. Dox. I appreciate it.
Thank you to your staff.
Mr. Houston, come on up.
Good morning, Your Honor.
Good morning, sir. Christopher Broad-Knox.
Yes, sir.
Ready, Your Honor.
All right.
Calling case number 2405758601. People of the state of Michigan versus Christopher Broad-Knox. Defendant is charged in count 1, assault with a dangerous weapon. Count 2, weapon stolen, firearm. Count 3, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drake for the people, key number 60249.
And good morning, Your Honor. May it please this honorable court and your staff, Melvin Houston, P number 36280. Hearing on behalf of Mr. Christopher Broad-Knox, who is standing to my left. Mr. Broad-Knox, would you state your full name for the record?
Christopher Broad-Knox.
Today is the date and time set for preliminary examination. Are you ready to proceed?
Yes, Judge.
How many witnesses?
I have one witness here.
Your Honor, in view of the fact that the witness has appeared, my client has decided to waive his right to the preliminary examination.
Okay, sir, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You understand you have a statutory right to have a preliminary examination by waiving the same. That means you won't have one, and you'll be bound over to Lane County Third Circuit Court as you stand charged. Point form. You understand that?
Yes, sir.
You understand the nature and the purpose of the preliminary examination?
Yes, sir.
You understand if you were to have one, the prosecution will have to establish that the crime you're charged with was committed in the city of Detroit if there's probable cause to believe you committed. Is anyone forcing you to waive your right?
No, sir.
Does anyone promise you anything?
No, sir.
Are you waiving your right freely and voluntarily?
Yes, sir.
Any objection from the people?
No objection, Your Honor.
The court finds defendant's waiver is made knowingly and voluntarily free to give the court will therefore bind the defendant over to Lane County Third Circuit Court, Criminal Division for further proceedings. We're open on July 5th. Circuit Court open on July 5th. Defendant's arraignment on the information date and time will be July 5th, 2024 at 9 o'clock a.m. Bond will be continued.
Your Honor, we would ask the court to consider changing, not necessarily bond, because that's a personal bond, but the requirement that my client wear a tether.
Why? It seems to be working.
Yeah, it's certainly working. There's very little doubt about that.
So why should I change?
It is creating a real inconvenience for my client in terms of obtaining employment. He's been rejected at least once, possibly twice.
Oh, wow. Tell me about it.
I actually went to an interview at Rite Aid, and she actually gave me a job. Went off. She told me I got this taken care of back. So, and I can't even look for an apartment because I can't go nowhere. I'm trying to have to move. My dad is moving in July, so I don't have that much time. I can't even go look for an apartment. I'm stuck. I haven't seen my kids in 3 weeks.
Ms. Drain?
Your Honor, I can go speak with the complainant over.
Okay.
I'm scared.
Ms. Castor?
Good morning, Judge.
Good morning. What are you here on?
I have Mr. Last name DANG, Mr. Dang, for a PCC.
Dang, you didn't want to say his name?
No, Judge.
Dang, okay.
I'm trying to get it correctly.
Hold on, before I call that, what we got, Ms. Drain?
Your Honor, the complainant has left after it was made.
So what's your
Don't have
position?
any information. At this time, I would object to the charter being removed. I'm not objecting to hours being changed, but I am objecting to it.
Okay, let's do this. Let's keep the tether in place. However, I won't have him, it won't have any restrictions other than he have no contact with planning rules.
Thank you.
So then he can go and look for his apartment and that type of thing, but don't come anywhere near her.
Oh, I
Or
don't
place of
want,
employment.
I don't want to go around. No. Oh, you got to work.
All right, Mr. Houston, I need an order to that effect.
Okay.
Can I have a better statement?
So you get the order.
I'm gonna get an order. Okay, dang, you gotta do dang.
Calling case number 2405-776201. People of the state of Michigan versus Stang Dang. Defendant is charged in count 1, assault with a dangerous weapon. Count 2, weapons felony firearm. Count 3, interfering with crime report. Count 4, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drake for the people, T number 60249.
Good morning, Your Honor. Attorney Nancy Castro appearing on behalf of Mr. Dang. I do apologize for the background noise. I am in the hallway of another court.
All right, and what's your pleasure, Ms. Caston?
Your Honor, if we can schedule this matter for a preliminary examination, please.
Is Mr. Dang in custody or not?
To my understanding, he is in custody, Judge.
All right, let's do June 28th at 10:30.
1 second, Your Honor. That works for the defense, Your Honor. Thank you. I'm sorry, you said 10:30?
10:30.
Got it. Thank you very much, Judge.
Final continue. Thank you.
And Ms. Drain, if there is any digital discovery, can you please send that over to me? I have the paper discovery, but no digital.
Okay, I will send it. Thank you.
Thank you. Take care, Judge. Have a good weekend.
You too. Is Bush in custody?
Yes.
Oh, that's Bush. Well, who is this Bush that I have here that's been? all over the place.
I think I left it on. Yeah. Briggs, about art case, she doesn't have all the discovery. She said she'll, zoom back in.
Can you work from this friend? I'll reach out to her.
And the new comp here in the September bill.
Okay, so we don't have to get to it.
Yeah. It should be.
Okay. What's up, Mr. Houston?
She's happy.
Oh, okay.
Tired,
Yeah. Sure. Mr. Collins here yet? Oh, yeah. Good morning, Mr. Washington.
Good morning, Your Honor. How you doing?
Doing good, so good, sir.
Well, I'm here on, yeah. Come in, he's out in the hall. Thanks.
Yes, sir.
Should I have him come to the front?
Where?
I don't have any proper goals. I had just one. I ain't have, this is literally all I got. I lost everything with this situation going on. I lost everything. Trust me, I didn't wake up to be dressed like this, just to come here and like make you mad.
Mr. Collins, you ready?
Yeah, Judge, come see my client and see if he's in the hall. Ready to do something.
Is he here, Mr. Collins?
He's walking in the building, Judge.
Okay.
For Madam Clerk, on yesterday, I did tell him time was of the essence.
Okay, Mr. Collins, Mr. Washington.
Call me, case number 2405-626801, for the state of Michigan versus Briggs McLaughlin. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder or strangulation. Count 2, animals abandoning cruelty to one animal. Count 3, malicious destruction of personal property, less than $200. Count 4, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Green for the people, P number 60249.
Good morning, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Breon McLaughlin.
Your name for the record, sir.
Breon McLaughlin.
There's the date, time, set for preliminary examination. Are you ready to proceed?
Your Honor, I'm not able to proceed at this time. The complaining witness was notified of today's date, time, and location. She is not present. I cannot proceed without her testimony today.
Your Honor, defense moves to dismiss.
Mr. McLaughlin, tell me again why you're in the courtroom with short, sir.
Why again? This transaction, I had to go to the mental hospital. This one that has, I just started back working, literally the beginning of this week, Monday. I done lost 2 different jobs because of this altercation. And I only met them, I didn't even know the one longer than 6 months. I only met them for like 3 months.
I just asked you why are you wearing shorts?
Because I don't have no clothes. I just got my social security card literally Wednesday. I just got my license back. I lost everything. She took everything out of my truck when I was arrested, and I'm working to get everything back.
You don't have any clothes. That's the only clothes.
I don't have any clothes that is uniform, presentable for court. No, I don't.
You don't own a pair of pants.
No, sir. I only wear like joggers and everything. I'm usually a high-low driver. I work in plants. We don't have to, I don't think I have to really wear the steel toes. And I don't even have none of those. This whole transaction, this woman is way older than me and everything. I lost everything. I'm so serious. I just used change to even get here to pay my gas tank. So if that's what you asked me about, that's all I got to say about clothes.
We'll dismiss this matter without prejudice.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor.
Dismiss it.
Case number 2405-744701, people in the state of Michigan versus Christopher Kenneth. Defendant is charged in count 1, police officer assaulting, resisting, obstructing. Count 2, knowingly assault or assault and battery of pregnant individual.
Appearances for the record, please.
Good morning, Your Honor. Shelley Green for the people, P number 60249.
And good morning, Your Honor. Harold Collins, B56805. Christopher Conley, who stands to my left. State your name.
Christopher Conley.
There's the date and time set for preliminary examination. Are you ready to proceed?
Yes, Judge, I have one witness.
Judge, I talked to Mr. Conley about his opportunity to hold an exam in this matter. He understands that right. He has decided to waive that right, Judge.
Mr. Collins, please raise your right hand. Conley, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, and you'll be bound over to Wayne County Federal Circuit Court as you're saying charged with claiming law. You understand that?
Yes.
You understand the nature and the purpose of a preliminary examination?
Yes.
You understand if you were to have one, the prosecution will have to establish that the crime you're charged with was committed in the city, was probably because of the belief you committed.
Yes.
Is anyone forcing you to waive your right?
No.
Has anyone promised you anything?
No.
Are you waiving your right freely and voluntarily?
Yes.
Any objection from the people?
No objection, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily freely given the court will therefore bind the defendant over to Wayne County Federal Circuit Court. Criminal division of the proceedings is arraignment on the information date and time of July 5th, 2024 at 9:00 a.m. Bond will be continued if there's no objection.
No objection, Your Honor.
Bond
Judge,
continued.
you did give us some room with the tether. He has a no contact order, and I don't know that the tether is necessary. That's the court. He's compliant, he's working, he's having no contact with that.
So the tub is working. It was designed to do, right?
It is.
Okay, I'll continue.
Okay, thank you, Judge.
Thank you. All right, how are you?
Yeah.
Zoomed in. Morning, Mr. King.
Good morning, Your Honor.
How you doing today?
Doing well.
Where's Mr. Richie?
Went to the call, 1 second.
Ready, Mr. King?
I guess I am, Your Honor.
I'm sorry?
I guess I am, Your Honor.
Okay. Calling case 2457594, people of the state of Michigan versus Jesse Leon Richie. Defendant is charged in count 1 assault with a dangerous weapon, count 2 assault with a dangerous weapon, count 3 domestic violence. Defendant has an additional court defense notice. Appearances for the record.
Good morning, Your Honor. Shelley Green for the people, number 60249.
Good morning, Your Honor. James King, you have Mr. Richie, P number 85229.
Mr. King, you have 2/3 of my name. Where is Mr. Richie?
I am unaware, Your Honor, Mr. Richie's whereabouts. Our office has made attempts to contact him to no avail. I am interested, however, to know if there's a need to go forward, if we have a complainant or not.
Doesn't matter because we have to get to point A before we can get to point Z.
Sure.
Court will issue a capious revoke bond and set the new bond at 25,000 cash.
Thank you, Your Honor.
Thank you, Judge.
Okay.
Anybody have a question? It's right. It's Frederick going. It's hard going.
So I think it's outside.
Oh, okay.
Yes, I saw him 7.
You got the other ones?
Yes, it is.
They going?
I just need one.
Emerson and I.
Jefferson. Emerson.
Mr. Vella, we're just waiting. Mr. Vella, we're just waiting on Mr. Johnson to come back. I can't hear you, sir. No sound, Mr. Vella. Mr. Fellows. We can't hear you, Mr. Fellow. Do you have something plugged in? Morning, Ms. Frederick.
How are you?
Good, how are you?
Am I next or should I wait out here?
You are next. Ready on heart?
Yeah, you send a heart.
I had some concerns, but we couldn't coordinate with you this morning. Prosecutor was in one courtroom over across the street, so was I. We kind of stayed in your waiting room and it was just a mess, so I guess I'll make a record and take your ruling.
He is, Judge.
Okay, yeah.
Okay, let's get ready on heart. Mr. Phillips? Okay, I can hear it now. I heard your background noise anyway.
Yeah, I'm sorry, Judge. I had to connect on my phone. I don't know what's wrong with my computer. The volume is not working.
No problem. Please remove your hat, sir.
APA said you secure my minutes.
Sorry.
APA said you secure my minutes.
Who's the APA?
He's a new one. I never met him before, Judge.
Tell him I don't have a few more minutes. He's sticking around.
I guess 11 o'clock.
It is another number.
Oh.
Because last time.
I'm getting blood. Yes.
It's open. Okay. It's open. Hey. How are you?
Judge?
Yes.
I can cover the, probable cause conference for Karina, but.
Mr. Bell is back.
Okay.
And Judge, I'm sorry, but I'm actually, I stepped out of an evidentiary hearing to come here, but I know that judge wants me back. If possible, can Ms. Drain cover for me?
Okay.
And I know this matter is just going to be set for, imagine a preliminary exam.
Does she have your dates?
I'm available the next 3 Thursday afternoons. Unfortunately, I start a murder trial on Monday, 24th. I start another murder trial on Monday, July 1st. But I imagine that I can get a break on those any Thursday afternoon for the next 3 or 4 weeks.
Well, you gotta take away one of those, because one of those is July 4th.
I apologize. I'm looking at my calendar. That would explain why I'm open on that day.
Right.
Well, so I'm sorry, would the court excuse me then and allow Ms. Drain to cover for me?
You have any Tuesdays available?
I imagine I'm going to be in jury trial. Again, I start a murder trial on the 24th, start a murder trial on July 1st. I do have Tuesday, July 9th open, as well as the 11th. Either of those dates would work, morning or afternoon.
See if I can work the 9th.
Okay, thank you, Your Honor.
All right, thank you.
Thank you, Ms. Drain. I appreciate it.
Sure.
Attorney locked herself up. She locked herself in there. I don't know, she might be a prisoner.
I guess that's off somebody's bucket list. Amen. Oh, that was crazy. I went over the door, I'm like, ain't no handle.
Yeah, we ready on Tony Hart? Oh.
Time yet?
Still got 10 minutes. Good morning, sir.
Mackenzie Wheeler. AKA Wheeler. I'm on Wheeler, WHEELER. Mackenzie, MICAENZIE.
Mr. Wheeler, are we ready to proceed?
Judge, we are. I thought we were scheduled for 11.
We are.
Okay. Do you mind if I take these last 8 minutes? I'm still speaking to my witnesses for you. Thank you, Judge. I appreciate your flexibility.
Just your in contact. Is it like? location? Okay. Do you want an update? Sure. Okay.
It's going to be MIA. Hart, HART.
Okay. Are we ready for Mr. Hart now?
Yeah, we just have some, sorry, after you call this.
You ready, Judge?
Yes.
Sir. Step up. Stand next to your attorney.
Case 2457469, for the state of Michigan versus Tony Maurice Hart. Defendant is charged in count 1, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older. Count 2, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older. Count 3, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older. Count 4, child sexually abusive activity, aggravated. Count 5, criminal sexual conduct, assault, intent to commit sexual penetration. Appearances for the record.
Good morning, Your Honor. Mackenzie Wheeler for the people, P86308.
Good morning, Your Honor. Lisa Carter, P53372, appearing on behalf of Mr. Tony Hart, co-counsel.
Good morning, Honor. Neighborhood Defender Service of Detroit by Nancy Richards, P68850, appearing on behalf of Mr. Tony Hart.
Haven't seen you in a long time.
It has been a while.
Your name for the record, sir? There's a date and time set for preliminary examination. Are we ready to proceed?
We are, Judge. I think we have a matter before we call witnesses to discuss, but my witness matter.
Actually, we have a couple of preliminary matters, and one of them is counsel messaged me yesterday evening indicating that he had just received a group or set of CPS reports and was only able to redact one, so there were remaining 6. I feel like I need those as they predate the charges on this case. We were in court in your Zoom, hoping to get the court's agreement for an adjournment because there are outstanding concerns with respect to the discovery. One of the reports that we do have indicates by a check mark that there was a medical examination done. We don't have any medical records on this case. However, the report indicates that there was such an examination. We're just hoping to kind of get counsel's effort to get all of the discovery together instead of the trickle, as I indicated. One report came in yesterday, but he indicated he had 7.
That's correct, Judge. So I received, I think 8 actual total CPS records yesterday.
Did you intend to use those records in some form or fashion?
Not at this point, Judge. No, I haven't even finished reviewing it. At trial, this would come to trial perhaps.
So as it relates to CPS records, why would you need those records?
Because they would help me to determine how I would establish questions and formulate a defense at this juncture. We are here. And so if these reports predate the charges, then they might be relevant to what we're doing here today. So I would reserve the right to have them.
Wouldn't that be hearsay?
I still would like to review them for my purposes of providing a defense for my client. And because he has them, we should have it.
Judge, I mean, I haven't finished reviewing them, but I did provide the most recent one, which when I reviewed it it was relevant to today's proceeding. It was where the children did disclose the sexual abuse. So for my argument would be that is the most relevant one here, and that one has been provided. And Judge, I received them last night. I think we would have gone forward with the exam even if I hadn't gotten them. It's just what happened that I got them at such short notice that I haven't been able to provide them.
Well, I don't think that, and I don't want to belabor the point. I don't think that counsel's determination as to what's relevant to the defense is controlled here. I think that discovery means what it means. And when he received these documents, he should have stopped the process and said, hey, I've got some potentially relevant information. I need to get in touch with counsel. We need to talk to the court because I need time to review those. For him to review one, select one to review, and then decide that that's the one that's relevant is improper. The discovery order is what it is. And in fact, we do have an order on this case. Not only do we have an order, we have a protective order. So we got stuff moving in this case that kind of sets the parameters for discovery. We deserve it, we have a right to it, and council has it and hasn't turned it over.
How long is it gonna take you to get this information?
I mean, I think it'll take me, probably the rest of the day to do it, if I would start right now. It's just, there's a lot of personal identifying information I have to redact out of it. That's what's, and so probably a total of about 100 pages.
I have availability for next Wednesday, June 26th, almost anytime.
Your Honor, and as to the other matter that I indicated to the court, so we have information via the kids talk that there are specific and particular allegations against the male child in this case, levied by his sister. And we would ask the court, we've already inquired of counsel whether or not the child has immunity to provide testimony and proceed in this case, because he is in fact alleged to have committed similar acts as alleged against his father as it relates to the two sisters.
So, Judge, we don't have any immunity in this case at this point, and I don't believe you will require that. It's not, and again, I'm not sure it to be handled when we are taking testimony if we get that far. I don't believe that the male victim in this case is going to testify to anything that will require him to be advised of his rights. But just from what I have seen so far.
Well, it wouldn't be the male victim testifying as to things that would require him to be advised of his rights. His sisters are alleging the same conduct against the male victim. Therefore, he would be potentially a defendant. So therefore, he would need counsel. It's not him alleging conduct of his own. His sisters are saying that he violated them in the same manner that you're alleging against them.
And
you're talking about him, perhaps if he's called to testify. Trying to understand where you're going with this, because it's like you said, the sisters that may have a claim against him, but what does that have to do with him testifying?
So when the kids talk, and I forgot at this point, counsel reminded me, in the kids talk videos, the male child does in fact indicate that his father threatened his life and forced him to have sexual conduct or sexual contact with his sisters. Okay. So that is in one respect. The other one is the allegations against him by his sisters.
Again, so he comes forth, he testifies, and what?
Well, he's already said in the kids talk that his father forced him to have sexual contact with his sisters. Okay, and he's also being alleged to have had that contact without force from his father by his sisters.
Say that again.
So he's also alleged to have had sexual contact with his sisters.
Alleged by who?
His sister. In the kids talk that they, yeah.
Judge, he'd be open to cross-examination by the defense, and that would be an area we would need to cross-examine him on. So, because it goes to the allegations, it's, it does, because one of the allegations is in regards to.
Well, the allegation that the father made him do something, but without the father, how is that going?
It's relevant because, well, first of all, it goes to credibility and bias. Second of all, it's part of the case. It's facts of the case that he's talked about in his kids talk video, as well as so have the sisters.
What's your position?
Judge, our position is that, and I anticipate the testimony will be that his dad forced him to have sexual contact with his sisters. So if you're forced to do that, it's not as if he's going out on his own. He's not going to need any legal representation for that. That's all just part of the case.
Okay, but they also say that there were instances when the father was not involved and he still had sexual contact with these sisters.
And I'd have to review the kids talk again, but my memory of it was that he was acting, his father threatened his life and said, if you don't have sex with your sisters, I'll kill you. And his father then left. And that's when he did have sexual contact. So that's all part of that ongoing threat by the father.
You want this witness to come forth and testify. Why not cross your T's and dot your I's and offer use of immunity?
Well, Judge, I just don't think it's going to be a necessary thing to do here, and rather than create an issue with.
But again, in the interest of crossing your T's and dotting your I's, why not?
If we offer him immunity, then that opens up, an argument that his testimony is being induced by us in some way, that we are giving him some sort of carrot for him to testify in our favor, and because
also in protection of him.
Right, and it's something that we can explore. However, I have spoken to the male victim in this case, and I don't believe his testimony is going to be anywhere near requiring any sort of use. Again, he's a child, so I can't tell you exactly what his testimony will be, but I don't think.
They're not limited to cross-examination. They're going to go all into these specific acts.
Right.
And if he's on the stand, if he's putting himself in jeopardy, then again, why not cross your T's and dot your I's?
Your Honor, if I could say just one thing. We have a leaning toward defense, right? And the moment this potential issue came up, I thought was he needs coverage because we do have a right to go where we need to go to protect him. So our instinct was that what would be the problem or harm in getting this kid coverage?
I tend to agree with you.
Yeah, we could probably do it. I think we need a better chance to speak with that witness in here, or not in here, but to determine exactly what happened.
Well, you'll have from now until June 26th. What time did we say?
We didn't pick the time, Judge. Let me see.
Judge, if the people aren't going to get immunity, then I believe the witness needs counsel.
So anytime, Judge. Got one thing.
Say anytime?
Yes.
Okay. Let's do June 26th at 11:30.
Right. Can we come before 11:30 or after? I just realized I got one hearing at 11:30 on the nose over at Frank Martin. And I can get coverage. It's not significant. I've already got dates on it.
Okay, you could get coverage.
Take 11:30. Okay. Your Honor, the court, okay, you've already spoken about the CPS records and those need to be turned over before we get back here on the 26th.
Right.
Yeah, that won't be a problem.
Okay. June 26th at 11:30. Bond will be continued. Thank you.
Thank you, Judge.
Well, folks, that's gonna do it for me today. Hope to see you Monday, same bat station, same bat time. Judge Jefferson will be here to finish the rest of my document. The next 2 cases. Mr. Johnson, at the same time.
Your Honor, can you please give us the bond information for this number? I don't have any of these family members back.
I believe he's on the remand. Yes. Yes. Thank you very much.
Bye, everybody.
So I left the calendar up here for Judge Jefferson. I think I told Mr. Bella. What I told Mr. Bella. Remember what I told Mr. Bella? I know I told him on Tuesday. I said July 9th. He said Thursdays are good for him. So he can do July 9th or July 11th. July 11th would be at 10 or 1:30. July 9th would be in. Have a good day. Guys, have a good weekend.
How you doing?
All right.
I think Judge Jefferson, I know Judge Williams just got the job. He ain't doing that.
He actually right there in the hallway talking to the prosecutor.
Ask him. Right. You got to talk to the prosecutor.
I know the general talked to Judge Johnson.
What's going on? Excuse me.
You can ask.
All right.
All right.
Excuse me.
Yes, sir.
What's going on?
We
Yeah.
switching judges.
Hey,
Yeah, and we gotta wait on your attorney.
Is there any chance I can see him?
What?
yeah, I'm going to try and look at it.
Alright, thanks.
Oh, thanks, thanks.
Yes. I have to.
Good. I hear we've got the plan here.
Are you Matthew?
What's your name?
Sorry,
Y'all switching.
No, he went around trying to find a judge, I guess. Yeah, that's what he called, yeah.
So we got on back out of it.
We got one for the answer.
Match key program.
I should be just. He killed me with that. I ain't calling about it. And that girl do it too.
One, what?
We talk all slow. Oh, Charles, I can't comprehend.
She got three more cases.
Oh, sorry, I'll be right back. Yes, with the reserve.
So I was trying to get yeah. She can call me, let us know. When they call him back.
Kind of nice.
Yeah.
So when you dismiss them, can they reinstate them again?
Yes, if they don't, like, good reason, then yes.
But if they don't want to follow through with the charges?
And if you stay dismissed.
I remember some of them that stayed in it anyway.
Yeah, that does happen sometimes too.
Why is it?
Yeah.
What did the priest say? He said he was older? Huh? For Anderson, the priest said he was older? Wait.
He's,
I think he's hoping.
He always old.
I always hold. You know me.
So,
I talked to a defense attorney earlier this week who was like, I'm holding my second exam. I was like, your second exam ever? He has a 100% victory rate exam.
Who's this?
100% victory rate exam. He does a lot of stuff down the river. It's just like a very different style of practice. Like never holds anything. I hold everything. Wow.
They take all this fruit over to Frank Murphy?
All the way.
Found over?
And the one he did, no, he got an assist the one time that he did. But for mine, yes, almost all of them were. I had Judge Archer stop an exam once to ask me why I was holding the exam. No, she was genuine. She was like, what am I missing? Like, you're holding this for a reason, right? I was like, no, I'm just holding the whole. She was like, oh, I thought like maybe there was like a Fourth Amendment thing or something I was missing. I was like, no.
I like Judge Archer.
I do, I like Judge Archer.
What's your name? All right, have a seat.
Charges. I get that. No, I don't, I will wait for that frequently.
Yeah.
But I've also had occasions, not so much in Wayne County, but where they'll offer to drop something. Someone drop it at that or something. You know, sort of the, you look at the police, right? You drop the. But we don't do that, that's not so much here really. But. Is he in the back? Yeah.
Yeah, he is.
Make sure it's like it's him.
Yeah. Justine. How many cases are there? I missed you too. Yes. How many cases are there? So we got one that's going on now for Judge Jefferson, which is supposed to take. Mr. Briggs got one case, he's going home. And then about 12 o'clock case, 95%. That's all that. All right. You know why Bush is still up on Zoom? Madam Court Reporter.
He's waiting for the judge to do something, I don't know. He's been sitting there all
day, yeah. So this is at a PC.
Yeah, he did what he's supposed to do, his attorney. And the judge was waiting on, the attorney never came, so. You know, Nika told them that they're waiting for the other judge. Right? Yeah.
Jefferson said she got 2 more cases. She'll be down here to finish up 2 cases.
She done with her docket?
Nah, she got 2 more left.
So she like her, the people to be ready,
Right.
and then place when she get here.
And making it.
Gotta move it happen.
I move to dismiss for no judge. If we stay here long enough, is it like, when you're in school and after 15 minutes, if the teacher's not there, you're allowed to leave? Is that how it works?
No, you have to stay until the judge relieves you, whatever judge is coming.
When you say to a judge, he shows up late. Good morning, Your Honor. Same thing you say if you're on time. Is it, the king's out?
Yeah, he had to leave early,
Who do we think we're gonna get?
Judge Jefferson.
I think it'd be her or maybe Giles.
Giles is better.
For defense?
Yes, absolutely.
Giles is,
I very rarely have I ever heard her not send it over. I know very rarely. This is probable cause.
Did I hear somebody was covering his job?
what was it?
Like, did I hear somebody was covering the job?
Oh, is that, so we've got multiple judges.
Giles isn't here.
I believe 9.
Man,
Just a single.
you about to get locked out of the building.
You guys saw the special dispensation that we could go all night, right? You didn't have it planned. Yeah, no, Giles is different. Jefferson, I don't think I've ever wanted to be Jefferson.
I've never heard. But it's just probable cause, so.
Well, like Jefferson's a good judge. I've had, you ever heard of Logan?
Yes.
That is a judge.
Yeah, I live in that.
Okay. Lowe is a, I'll put it this way, I wish him a good time in his retirement. Happy that he's taking the chance.
Some of the district judges are a little different. No, man, you were, I got so.
It's a big work. It runs like one of those things.
Choose. Nothing else.
Wow, this was, I think, 2 hours after the practice. And he said, another associate, she said, it was like, why did you just do it? He said, there's like no. Because when you ever get to see a lot of fights, so he said they waited there to be, he was like, yeah, it's really good. But I always thought that was true. The only things that they used to be tracked to it. We used to have,
Foreman used to get all the others.
and that was,
You end up having Secretary of State, get them on probation and they're out there working. They still did it.
I think they still have the license appeals, but I believe the tickets have now.
Oh, no, I don't. It was the license, yeah.
No, I did a traffic ticket, like, speeding by. And I do appeal, they're doing to break the car. And it was like a 4th Amendment. They supposed to stop. It was a business stop. So it was like 2 hours. Waiting for contract stuff. And we were following us, and I was like, well, that's what he was like, oh, it's in small school, like, tell me more, like, what's the argument? I was like,
Yes. Especially fan.
that is.
Always do somebody else. DVDs, because it was virtual. One thing, they didn't have. So some other judges, the new judges can't get. Yes, but the older judges, they. Now, they moved. Working to the new.
Yeah, and I know they said all the work was moving in August. All I heard. All I.
Get the one for the first guy.
I gave it out. It's not on your desk.
Huh?
It's not on your desk.
No, I don't see it.
And I know. To me, the best is.
Turn it over there?
Yeah.
Oh, I got it, yeah, thank you.
That's a nice thing. I don't like that.
Anybody says, can you check that?
You ever had them ask you to try to do something that?
That's why you do that, I guess.
I know.
Oh, no, it's more.
I'm sure. I never. That's why when I started, I just told them. I already, first time meetings on the committee. They have reporters' box, just somebody questions transcripts. You know, I reported it, because sometimes the judges actually, like, most of it's reported. You know, the better. Seasons. And he said that it sends in prosecutor text. Defer jury. He's fair. You guys want to bring up the water? Oh, boy. Last time in the jury trial. We don't do jury trials. Well, no, but like in this courtroom. Oh, Arnisha, when's the last time they had a jury trial in here? Has this room ever been used as like a actual? The judge was here.
Not since we've been in here.
I was gonna say, it's been, exams came back, what, 6 years ago, came back across the street. 6 years.
We came back in 2018.
What was this? Oh, this was,
This was Judge Archer's courtroom.
oh, yeah, so she might have done a trial.
Yeah, and then just Jones had it. Archer, Jones.
They're in practice now. I don't think preliminary exams never had any jury trial.
No. I just meant like when, you know, because I do remember, I had forgotten.
I know traffic, I know Land Lieutenant.
They're recording on jury trials. So I'm just right.
Oh, I know, she gets very
Recent,
upset.
very recent.
Very upset.
I certainly understand that. I know I had a,
Now I'm come Monday and Friday.
I had a jury trial.
It's not over there, I don't know.
6 weeks ago.
Oh,
We
well,
summoned 50 juries.
It's paid up.
Only 6 children. We thought about just trying to see them, to see if they work, but seeing that we knew that we had the most perfect. Because nobody even knows. Literally, you have to sit them and be like, this is like a perfect hand, like, well, what do you know? So we didn't even try. I think we are, Judge. Let me go find the prosecutor.
Well, check it. It's actually the same. Yeah. Oh, you got it? Okay. We did have one PCC law, the attorney hasn't shown, we may have to put him on the document. This piece of law on the front G. And the attorney never showed up. Our attorney. Monday to Monday, yeah. Here. Do we have to go on the record? Okay. Let me let it go.
Mr. Bush? Mr. Bush?
Yes.
Can you let the jail know to bring you back Monday morning?